Ted Cruz addresses some bad SCOTUS case law. Good evening, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Yes, over the weekend, Senator Ted Cruz of Texas spoke directly to a U.S. Supreme Court, or SCOTUS, precedent that he found, quote, clearly wrong, unquote. He chose Obergefell versus Hodges, docket number 14-556, in which SCOTUS held that states may no longer define marriage as they see fit. In choosing that case, Ted Cruz picked the one case among four that Justice Clarence Thomas mentioned as depended on substantive due process that has the weakest support. We're going to talk about that and about how maybe he didn't advance the strongest argument against it. To do that, America as a country needs to come to grips with the abandonment of civilizational values. The reason we still have so many bad precedents is that Americans have tolerated them for too long. So their reversal will require a great awakening. America has arguably had four. Accounting before and after independence, we need another one. Before I begin, I do want to shout out to the sponsor of this channel, which is Conservative News and Views, link in the description. Be sure to check out the awesome CNAV store. Scroll down near the bottom for that link. Lots of good merchandise there, including this t-shirt. Not your body, not your choice. Now, you'd think that case would be more relevant to a discussion of the court's decision in Dodge v. Jackson Women's Health. Well, it is, but it's also relevant to the case at hand because, as I intend to show, the child is the forgotten entity in this constitutional controversy. Tonight, I come before you to change that. Now, sources for Ted Cruz saying what he said include CNN, NBC, Axios, and the New York Post. The motives for their covering this story are as many and varied as the sources themselves. Now, maybe the Post sees a sensation, and sensation sells. But CNN, NBC, and perhaps Axios all want to show that Ted Cruz is an example of advocacy of theocracy. Now, all of them seem to quote Ted Cruz the same way, and he's had plenty of time to correct any errors, so let's assume they got him right. So what did he say? Excuse me. Well, essentially, he held that SCOTUS overreached for that decision. First, the decision overrode more than 2 centuries of custom and tradition. Actually, it overrules thousands, not merely hundreds of years of definitions of marriage in all societies. But certainly it overrules nearly 300 years of American custom and tradition, going back to the beginning of the first of the 4 Great Awakenings in 1740. Second, Ted Cruz points out that the states were offering distant solutions to a perceived problem. Now that's the key, a perceived problem. The only reasons anyone had problems were entirely subjective. They went on feelings only. Why can't a roommate inherit the property of another roommate? Why can't 2 roommates adopt children just because they happen to be of the same gender? What difference does it make? That's a real problem, isn't it? John Adams could have told him what difference it made. But since 1875, America has followed the precepts not of John Adams, but of James G. Blaine. James G. Blaine promoted an explicitly atheistic statesmanship beginning in 1875. His Blaine Amendment would have explicitly forbidden the states to spend a penny on any program from which any religious institution could have benefited. Now, when his amendment failed the proposal in the Senate, he went to the states. 38 states, the number necessary to ratify a federal constitutional amendment, passed Blaine amendments to their constitutions. Now, Louisiana repealed theirs in 1974. Blaineism informed choices for the Supreme Court. That's why the court held as it did in Everson versus Board of Education of Ewing Township, 1947, and also Lemon versus Kurtzman and several cases before and since. That includes Obergefell. Ted Cruz didn't mention the composition of the court in those days. You had the liberal quartet, Breyer, Ginsburg, Kagan, and Sotomayor J.J. And arguably, Kagan J., who had had a personal interest in the outcome of Obergefell, should have recused herself from it. Then you had the conservative contingent of Alito, Scalia, and Thomas J.J. Next you have Chief Justice Roberts, who voted this time with the conservatives, not that it mattered. And last, but by no means least, you had Justice Anthony Kennedy, who swung for the liberals this time. Now, that decision came out in 2015. Then in February 12, 2016, Antonin Scalia took a vacation that he shouldn't have. He went hunting, and he stayed at the home of a Democrat. That night, he died in his bed. The local medical examiner pronounced him dead over the telephone. 3 days before, this small email exchange took place between John Podesta and Steve Elmendorf, two longtime Clinton associates. These two emails are on WikiLeaks, and I have links to both in the description. Now, first, here's John Podesta writing to Steve Elmendorf. I quote him loosely. Didn't think wet works meant pool parties at Martha's Vineyard. And now, here's Steve Elmendorf writing back. I am all in. Sounds like it will be a bad night. And yes, he spelled it N-I-T-E. We all need to buckle up and double down. Unquote. Now, that might not seem to prove very much by itself, but I need you to remember these immortal words. Once is happenstance, twice is coincidence, and the third time it's enemy action. Unquote, Ian Fleming. Barack Obama nominated Merrick Garland to the court, but the Senate refused to act. That fall, Donald J. Trump won election as president. He then made 3 nominations, the latter 2 of which changed everything. First, he nominated Neil Gorsuch to replace Scalia. Then he nominated Brett Kavanaugh to replace Anthony Kennedy. The year after that, he nominated Amy Coney Barrett to replace Ruth Bader Ginsburg. Now, I'm not going to bother quoting the out-of-control young woman who heard about Justice Ginsburg's death and started crying out in terror. That is incidental. What's not incidental is that a Biden campaign official proposed an anti-religious test for SCOTUS membership. And when the Senate Judiciary Committee advanced Brett Kavanaugh's nomination to the full Senate, Senator Amy Klobuchar of Minnesota actually blubbed to her colleagues the name of Merrick Garland. Now this is a good time to take a break, because I want to shout out to another sponsor, BitNext. This is your replacement for Zoom, Slack, Google G Suite, Microsoft Office 365, Dropbox, WeTransfer, and Chili Piper, among others. Unlike any of them, BitNext protects your content and communications so well that even the administrators can't see it. So this is your channel for secure comms, conferencing, cloud storage, and file sharing. Best of all, everything is back-ends. You don't even need client software. If you have a browser, you can use BitNext. So follow the link at the very bottom, give them a try. 28 days free of charge. You can't beat that with a stick. Okay, where were we? Ah, yes, that anti-religious test for SCOTUS membership from the Biden campaign of 2020. That one fact illustrates the problem that Ted Cruz either missed or sidestepped. That problem is, America stands at a crossroads. America has come to the end of the atheistic statesmanship of James G. Blaine and his modern successors. The Supreme Court overturned many of the precedents that the atheistic left holds dear in the 2021 term. At least one senator, Sheldon Whitehouse of Rhode Island, blurted out his fear of just that sort of outcome He cited that as his reason to vote against Brett Kavanaugh. But the court does not yet have on it a strong enough majority for consistent religious arguments to carry the day. Kavanaugh has said only that it is not for the unelected members of this court to prescribe moral outcomes. Barrett has said comparatively little. Alito in Dobbs held that ending a pregnancy was qualitatively different from, say, same-sex roommates sharing bed. To end a pregnancy is to destroy life. But where is the ruling that a human being has a right to be born? We're not going to get that without someone arguing for it. Similarly, we're not going to get a ruling that marriage exists between one man and one woman until all of America is willing to return to its religious roots, and that means an explicit return. That return requires an objective definition and recognition of evil. 4.5 years ago, contributor Paul Eidelberg from Israel set forth the basic problem with redefining marriage as God never defined it. That problem is, human beings think they can be like God, and they arrogate divine authority to themselves. Nearly 4 years ago, contributor Robert W. Peck of the American Constitutional Party highlighted another problem with the Supreme Court. In Masterpiece Cake Shop versus Colorado Civil Rights Commission, that's docket number 16-111, the same Anthony Kennedy who found a right under substantive due process for same-sex roommates to call their relationship a marriage, also found that the state of Colorado may not selectively apply its civil rights law. The problem of refusal to come to grips with objective evil remained, and it still remains. Rumor had Anthony Kennedy delivering 2 accommodations to conservatives at the close of the 2017 term and then retired. But Brett Kavanaugh, who replaced him, has made plain that he does not believe that the court should decide moral questions. He has rightly concluded that the court has promoted an anti-morality for too long. But if you ask him to uphold a civilizational morality, he might not be willing. Now, remember, John Adams specifically said that the Constitution was, and I quote, for a moral and religious people only. He understood objective evil. So he would never have countenanced anything other than an explicitly Christian jurisprudence. America is at this pass because the Great Awakenings did not go far enough. The only evil anyone is willing to recognize today is that which one individual might do to another. Even then, the extreme libertarian position might make murder legal. Now that does seem an extreme case, to be sure. But hey, most murder victims know they're killers. So the libertarian is going to put on them the burden of protecting themselves from their own enemies. No enemies but what you make. And when you make them, they're not anybody else's enemies. But what if somebody takes the life of a total stranger? Well, of course, if you attack someone, that someone may defend himself against you. I won't argue that point. But the state's prosecutorial power is one of retaliation, not immediate defense. And under the libertarian scheme, that stranger's friend has the right, even the duty, to avenge him, or likely her. So retaliation gets put in the hands of the victim's family, friends, or identity group. And when that happens, the identity politics of today will then degenerate into identity-based feuding. And given the peculiar nature of most one-on-one stranger killings, you could start the ultimate battle of the sexes that way. Nasty. Short of that case is the apparent decision to treat children like little adults. At least, and now at the very least, this means exposing them to adult temptations. Even celebrating the child who yields thereto. At worst, we have the grooming of children. And then blaming the anti-groomers when a groomed child, realizing what a horrible mistake he or she might have made, attempts suicide. Now, does Ted Cruz realize that? Well, nobody has adequately asked him. But all the Ted Cruzes of this country must come to grips with an objective that threatens the well-being, objective evil that threatens the well-being of children. So let's have that argument from about a human being having a right to be born. Let's have it in court. File the case of unborn child X versus fill in the blank. File it against the current governors and attorneys general of New York, New Jersey, Connecticut, Michigan, California, Colorado, any other state whose governor and or attorney general are using taxpayer funds for voluntary termination of pregnancy services or the aiding and abetting of same, including without limitation interstate transportation. While we're at it, file it against private companies who have announced their intention to so aid and abet. Discrimination is not a sufficient ground. The ground must be the termination itself. Sam Alito said that this act destroys life, so let's get a judge to confirm it. An argument for traditional marriage ought to be much easier than that. Now look again at the slip opinion in Obergefell. Never once did any court, trial or appellate, hear from a child growing up with two adults of the same gender. We've seen explicit grooming materials, but so far none has argued on behalf of a child that such grooming does the child an actionable wrong. It's time somebody did so argue. So before I close, I want to leave you with one final word, as in Word of God. Quote, "If anyone causes one of these little ones, those who believe in me, to stumble, it would be better for them to have a large millstone hung around their neck and than to be drowned in the depths of the sea." Matthew 18, verse 6. Look it up. Link in the description of the article to those two WikiLeaks emails 3 days before Antonin Scalia's death and the conservative news and views. I have another link to the awesome online store and a bit next, as I also mentioned. And if you like what you've heard, you can like this video. On the end screen, I'm going to put in a subscribe link and also a link to my Supreme Court playlist. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.